Hello, dear friends. I'm Sanja Gligic, Associate Professor of School of Law, University of Belgrade. Happy 10th University. I'm so sorry I cannot be with you during this great celebrity, but unfortunately these occasions right now, I'm hoping the next year will be better, but this is the way I can be with you. Today I will speak something a little about use and lex contrary to the practice of marriage law at the Kingdom of Serbs, Croatians and Slovenians. And since the subject of these papers falls under the international private law, it's important to point out that no other branches of law for understanding requires the study of history to such an extent as is the case with international law. In particular, we should not forget that it developed from what its founders indicate as natural law. Therefore, there is no right about all others, a right that even man cannot change that by his will, because it's a superhuman divine source. It is the right of everyone to get married. It's foundation of the family, which is the basis of national and the state's identity, as such influence social and public life. However, at the time of the Serbian, Croatian and Slovenian kingdom, there were a conflict of marriage laws, not only regarding members of different religions, but also regarding the state legislation. Legal particularism results in the inequality of citizens before the law, and multitude of hard of surround obstacles of realizations of elementary human rights to marriage, especially divorce, which after the issues of divisions of joint property, alimony and inheritance, violations many other rights. In the greater part of Austria-Hungary, the provisions of Austrian civil code were applied, according to which church marriage was mandatory. While in other areas, especially areas that were included in Croatian-Hungarian settlement, such as the city-state of Rijeka and parts of Vojvodina exclusively, Hungarian marriage law was applied in accordance with Article 31 of the law from 1894. This law was entered in force in October the 1st in 1895 and prescribed compulsory civil marriage. In addition, the most important basic principles of the marriage law were that it obliges every citizen to be treated equally by the state. This means that during the conclusion of such as marriage, the inheritance of different religions were not taken in account and divorce was allowed by the judge verdict on the basis of prescribable legal reasons. In order for the marriage to be valid, it has to be concluded before a civil officials. This regulation was valid not only for nationals but also for foreigners, according to the rule that the form of legal work depends on the state in which that work is performed, locus regit actum. In the area of Bačka, Banat, Prekomorje, this law was appealed in accordance with the Croatian-Hungarian settlement, while in Rijeka it was appealed de jure according to provision of Article 164 of the marriage law, because the question of her affiliation was not resolved with Rijeka's rag, but she was left to Hungarizations because she was provisionally given the status of corpus separandum. A similar scenario was repeated after the Rapallo Treaty in 1920, when Rijeka was recognized as independent state, but de facto power was exercised by Italian military officials. Hungarian private law was characterized by the fact that the customary law played a significant role in it, and judicial practice had a special lawmaking function in this regard. Here, above all, we mean the so-called decisions, judgments of highest Hungarian courts, instance, the so-called royal manners. The highest court instance in Vojvodina legal area was Department B of the Court of Cassation in Novi Sad, but an overview of the first instance judgment can be seen among decisions of the Court of Appeal in Novi Sad. On the other hand, the verdict handed only by this district court in Rijeka made it possible to learn about the application of Hungarian law in this area. Namely, since the establishment of the Royal Court of Rijeka in 1871, this court judged matrimonial matters in the first instance, while the Royal Court in Pesta and Supreme Court, which at the same time had the role of the Court of Cassation, tried in the second and third instance the cases. The principal decisions of the Court of Cassation or decisions did not have character of law, but courts and citizens adhered to those rules, assuming that the highest court would resolve a specific legal dispute based on them. The analysis of divorce judgments showed that the most problems in practice arose because those marriages in civil marriage were the easiest to get a divorce. The church of the marriage was valid in Vojna Krajina, so one judgment shows the Court of Cassation in Department of Novi Sad did not allow divorce since the marriage was not concluded before the register, which is why it considered that such marriage does not exist. The court established that the parties were married in parallel on November 28 in 1895. That is the time when Hungarian law had already entered in force. The first day the entrance in force of Hungarian law marriage was the October the 1st in 1895. The problem of church marriages of Orthodox Church was not served as in the case of the Catholic marriages, because divorce could be obtained under the certain consequences, exemplary for adultery. Precisely for this reason, a large number of divorce judgments of the District Court of Rijeka, which were handed down in the first years of the renaming of the Hungarian law, show that the court divorces only those Catholic marriages that were later concluded before the register. At the same time, Article 25 should also be highlights of the Hungarian law, which states that it's forbidden to enter in a civil marriage without permission of the higher church authority for someone who, according to the rules of church which he belongs, cannot get marriage due to the church order of voice. A similar practice was repeated later in the period of the Rijeka state city in the beginning of 20th century, but it can be observed that a large number of Italian citizens took Rijeka citizenship in order to be able to bypass the national legislation that did not allow divorce. However, with the entrance of Rijeka in 1924, as a legal decree was passed, beginning the institution of divorce. This practice of applying Hungarian law lasted longer in Vojvodina because it continued with the entry into the kingdom of the Slovak Republic and later under the end of the Second World War. It is precisely in that later period that can observe the opposite practice of the courts regarding the recognition of church weddings. Namely, in the area where the Austrian civil code and court, the Table of Seven in Zagreb in Croatia was appealed, he passed a verdict in 1939 where it pointed out that no legal regulation authorized the civil courts to declare the verdict of the church courts null and void, and even less are the civil courts competent to declare the marriage of the Orthodox to be null and void. In addition, in accordance with the locus regit actum rule, A church marriage concluded by a Vojvodina citizen in Greece or Bulgaria, where at the same time the form of church marriage was mandatory, it's valid, and would produce legal effects in Vojvodina. Finally, the religion of the future spouses was not taken in account in the areas where the Hungarian marriage was in force. In addition to problem of religion, practice also shows other problems. According to Hungarian law, a married adult woman was equally to adult man in terms of possibility to exercise her rights. She could perform all legal duties and was legally competent. In Serbia, it was different. The Serbian Civil Code stipulates that a woman is limited in her ability to do business, which means that she must have her husband's approval for any property disposal work. Now the question arises whether a Serbian woman legally married both civilly and ecclesially in Vojvodina to a Serb who has his domicile there and official has full business capacity, or does she remain limited in business capacity as it prescribed by Serbian Civil Code? If it's said that there is no then we have an absurd situation where two women live in the same place and in the same house, one of whom is able to do business and the other is not. If this question is resolved in a positive sense, then another question arises. Will this Serbian woman have business ability even when she moves to Serbia? If it's said that they will have, then it's against absurd situation of two Serbian sisters, one of whom got married in Vojvodina, then returned to Serbia, and the other in Serbia. The first will have business capacity and the second will not. Similar examples of house could be observed in all branches of private law, which is why this was better resolved in Rijeka than in Vojvodina, which after the validity of Croatian-Hungarian settlement became the part of Serbian, Croatian and Slovenian kingdom. After that, Rijeka was partially independent and had its own citizens. So perhaps the Walter statement that travel change laws as often as horses could use to reach the final conclusion that will be present in the finished work. Thank you very much and have a nice time at Sofia like I am with you. Thank you. Bye-bye.